Yes, all of them, they're there. Hello, hello, good afternoon. Uh, just a minute. Are you muted?
Sorry. Hello, I'm Hoyan from ICCK.
Okay, so can you hear me now?
Yes, I can hear you. Sorry.
Oh, that's great. That's great. I can see you as well.
Okay.
Great pleasure to meet you over the video.
Thank you. Thank you for being April's webinar host. Thank you for your help.
It's great pleasure. Great pleasure.
Hi, everybody.
Hi, Daniel. How are you doing?
Hey, doing good. So are you all ready for the discussion?
Yes, always. It's such a pleasure.
All right. So thank you, ICCK team for sending us the timeline. That's exactly what I wanted to discuss for the 10 minutes.
Yeah. Sorry for sharing at the last minute.
No problem. So I guess there will be an opening remark.
Yes.
10 minutes or so, and I will be speaking very briefly about the topics for today and introduce two of you, the speakers, and then I have Jack Bill comments on the customs related discussion.
No, Rupender on customs related. And I will be on insolvency.
Okay. So Rupender on the customs related issue, and then Jack Bill, followed by Jack Bill on the insolvency regime, which may be relevant to Korean companies doing business in India and or who intends to make investments into India. And on the customs-related topic, I do realize that the key discussion will be on the certificate of origination and how complying with various conditions for getting the customs tax exemption under the Korea, India, whatever. I guess it's not fair trade agreement, but to the extent it is related to the customs tax, is similar in, I guess, application. Is it basically?
That's basically, yeah.
Okay. And I understand that the whole webinar will be. Is it going to be a 90-minute session?
Yes, I think so. Yeah, it will be.
Yeah. Okay. So we'll if I have time, I will raise the questions that you have kindly provided to me, and to the extent that we are short on time, I will ask the participants to direct the questions to ICCK for onward forwarding to you guys.
Sure.
Actually, before we start the webinar, I'll make like a short announcement that if people have like questions during the presentation, they might leave it in the chat box. So later, maybe Mr. Daniel can if there are some questions in the chat box, maybe you can go over in the Q&A section.
Sure. To the extent there are questions that I can understand, I will try to relate to to you. To the extent there are difficult questions, I will use my discretion to skip those questions if it's okay.
No, if the questions are difficult, you can interpret it in your own way and pose it to us. No issues whatsoever, Daniel.
Sure.
We will be slaves to your instructions.
Yeah, good morning to all of you. Good morning, Mr. Daniel Yee.
Hi,
Yeah.
Daniel.
Yeah.
Good morning, Sinaji. It's a great pleasure to meet you over this video.
Yes, yes. So,
I'm Jagveer Singh. Rupinder Simar is my colleague, who
okay,
is the head of customs and international trade.
good.
This is
Yeah, we have lots of participants. They are very hopeful that this meeting, this webinar is going to be very, very useful.
Yes, yes.
So, lots of them have joined.
Oh, that's great.
And thank you very much, Jagbir Singh ji and Mr. Daniel E for joining this webinar, accepting at a very, very short notice. It's a real pleasure to have you here. And also, I would like to thank Mr. Jeremy who took all the pain to coordinate all this and bring you people on board.
yes,
Okay, thank you.
Jeremy has been instrumental.
Yes.
찾아뵙겠네. 이거 수업 어떻게 아, 아, 저희 거는 수업커 돼 있는 거죠. 이거.
So during the webinar, will the screen be showing me? You know, while Jagbil and Rupinder are having a talk, or is it?
So you saying controlling the system? You saying the PPT?
Just wondering who, what will be the participants be seeing? The same screen that we are seeing now?
Well, whatever way you, as I told you, Daniel, we are your slaves today. So whatever way you decide, please go ahead.
No. Yeah, it's just I will follow ICCK's traditional protocol. Just curious.
Yeah.
So will Mr. Jabar or Rupinder will share the PowerPoint from your side, or do you want us to share it from here?
It will be good if you can control it. In fact, so the speaker can really request you to change the PPT, next PPT. So next slide. Yes,
Okay.
it's easier. It's in fact, because see, probably the participants will be more interested in the Korean versions, and we may actually lose track of that when we do it.
So I showed I prepared the Korean version here, so I will share the Korean presentation on the screen then.
Oh yes, and we can each of us for our own uses, we can just shuffle through all those slides as we go through them
Okay.
one by one at our systems.
Okay.
Yeah. Fine. So yeah. So I think a few more minutes still.
Yeah, we wait for another 2 minutes and then we start.
Then we will start.
Yeah.
So, just Miss Kim, one thing.
Yes.
Is it possible for you to display both the English and Korean version yourself on the screen?
Wait. Can you wait one moment? I
Sure.
only downloaded Korean version on the laptop. So
Okay.
I think I have to set up for English one. Wait one moment.
Guys, we can use the English version at our end, and you can play the
Yeah,
Korean version.
that is also fine. That is also fine.
So, Mr. Jaibara will start the first, or Mr. Rupen?
Rupinder, Mr.
Yes.
Rupinder. Customs.
Yes.
So we start now.
Yes, we'll start now, sir.
So namaste and annyeonghaseyo. Good morning to our team in India and good afternoon to people from Korea. And it's a really pleasure for me. I'm Anil Sinha, and an honor for me to host this webinar. And currently, I have been elected as a chairman for Indian Chamber of Commerce in Korea. And this is what we do as Indian Chamber of Commerce in Korea, where we support the businesses from India and Korea and basically how the business and trade and business grows between India and Korea. So basically, our vision is to play a vital role and valuable role in economic development and trade promotion between India and Korea. And our mission is threefold, where we talk about development, awareness, and advocacy. In development, we promote Indian investment in Korea and Korean investment in India that lead to economic and cultural development. In awareness, we share business information on India with Korea business and Korea with India. Like we keep on getting lots of trade inquiry from Indian businessmen who want to do something in Korea. Similarly, we get lots of trade inquiry from the Korean businessmen who want to have some kind of a joint venture, technology transfer, or have a 100% subsidiary in India. So we work as a bridge between the Korean industry and the Indian industry and try to bring them together. And in case of advocacy, we advocate and support trade policy that strengthen commercial relation and improve quality of trade between India and Korea on behalf of all the stakeholders. We have members from Indian organization as well as the Korean organization who are member of Indian Chamber of Commerce in Korea, and we support from the business point of view as well as the cultural exchange point of view. That is another area which ICCK focuses on. So we have certain festival celebration and also some kind of a cultural exchange program. One of the very, very important thing is that where we conduct this webinar, which is beneficial to the industry as well as the speaker forum. Like today, Mr. Daniel E has been very kind and our Indian partner have been very kind to come on board and share their experience related to customs and trade between India and Korea. And we also conduct a webinar and the speaker forum where we invite key speakers from either India, Korea, or US, different geographies who participate on the topics which are of interest to the stakeholders. So that is another area where we are able to help out the businesses and bring awareness among them. So I would like to introduce Mr. Uh, Daniel Yee, who is our key speaker today.
Okay, thank you, Mr. Sinha and the Indian Chamber of Commerce in Korea for hosting this webinar, which should be useful to Korean companies doing business in India or who's intending to do business in Korea. 저 주한 그 인도 상공회의소가 주최하는 웨비나에 참석해 주셔서 감사합니다. 저는 그 법무법인
because this is area is the right is further. Okay, and this point. Okay, in case of the LDS, we found the longer code C and
죄송합니다. 네, 저는 그 법무부 율촌의 그 이태혁 미국 변호사입니다. 그 율촌의 아시아 팀 팀장으로서 그 인도를 비롯한 아시아 각국에서의 그 사업 및 투자와 관련해서 그 한국 기업과 금융기관을 도와드리고 있습니다. 그 오늘 세미나는 인도 유수의 로펌인 주피터 로 파트너스의 작빌 싱 변호사와 그 루펜더 샤말 변호사님을 모시고 말씀을 들어보려고 합니다. 그 두 가지 주제가 있는데 첫 번째는 그 인도의 관세와 관련된 것으로서 인도에서의 원산지 증명서 등 관세 면제 혜택을 받기 위한 요건에 대해서 살펴보겠고, 두 번째는 도산법과 관련된 것으로서 인도에서 또는 인도 회사와 사업을 하시는 한국 회사들에게 유용하게 적용될 수 있는 도산 및 파산법의 관련 규정에 대해서 살펴보려고 합니다. 작빌 싱 변호사님은 그 국제 M&A, 기업 자문, 공정거래, 도산, 기업이나 프로젝트 금융의 전문가이시고 제조업, 무역업, 서비스업, 또 전력 관련 업무에 경험이 많으신 분이십니다. 또 우리 그 루펜더 시나말 변호사님은 부가세나 관세 등의 간접세, 그리고 반덤핑 관세 등의 국제 거래와 관련한 조사 및 분쟁 전문가이십니다. 오늘 첫 번째 주제는 루펜더 신마 변호사님이 말씀을 주시겠고요. 그 다음에 작빌 싱 변호사님이 도산 등 이슈에 대해서 말씀을 주시고, 시간이 남으면 Q&A를 좀 진행을 하도록 하겠습니다. So we are done, I guess, introducing the topics and the speakers. Rupender, I will ask you to please. I think the slide should be on the 관세 customs.
Oh, sorry.
So we will be switching the slides into the customs related slides, and Upender will start shortly discussing the customs related issues which are applicable to Korean companies. Upender, do give us some time until we can switch the slides. Correct slides now.
And I think first of all, let me take this opportunity to congratulate Mr. Anil Sinha for being elected as chairman of ICCK. And I'm sure that your contribution would be immense to build a great relationship between the two countries and to help the trade, be it, as you mentioned, from India to Korea or from Korea to India. We look forward to this great contribution, and we wish you all the best. And
thank you very much.
Good afternoon to all of you. It is a pleasure to once again work in tandem with ICCK, and today we are giving a couple of presentations on two topics which we feel are very, very important and relevant for the Korean exporters. One of the topic which I will be dealing with relates to the disputes or complications related to goods originating from Korea and the relevant certification which is necessary when it comes to availing the trade agreements benefits under the India-Korea trade agreements, and the problems faced by the Indian importers by dealing with those goods which are coming from Korea. Whereas my colleague, Mr. Jagbir Singh, he'll be dealing with the issues post-import, I would rather say, the issues where the Korean exporters, they more often struggle to recover their legitimate dues from the Indian importers and the Indian counterparts. So first, we are starting with this topic as the rules itself says, the Customs Administration of Rules of Origin under Trade Agreements. So there is a trade agreement between India and Korea, and these rules are more to administer the concepts or the regulations related to origin of goods, which were recently introduced in 2020. And prior to that, there were a lot of disputes and complications since different free trade agreements have different norms for identifying what are the goods originating from a particular country. So they try to streamline the process and cut short the time with various timelines and responsibilities being casted on the importers. So we'll go through the history and then to the current rules and see where and how it helps us and how relevant these are in the today's time. Can we just move to slide number 2, please? So as we all know that in the modern times, today we live in a world with free trade, be it within the country or between two countries or residents of two countries, where things are moving from one country to another as per the needs, as per the agreements. So in order to have a basic document, mother document, the signatories of WTOs, and which includes India and Korea also, under the General Agreement of Trade and Tariff, which we call in short as GATT, which prescribes a parent document for two countries to have, so that they can identify the particular tariff items or goods where which are important or in requirement of need of the counterpart country, and they can give specific benefits in the form of exemptions or the preferential tariff, which gives a distinct advantage to the goods of one particular country as compared to the other. Take for an example, say a television coming from South Korea under the agreement entered between India and South Korea may have a duty of 10% customs import duty of 10%, whereas a similar product or good or television coming from other countries may have a duty of 18%. So this benefit of 8% is given under a particular agreement which is signed by two countries. Currently, India has 15 different free trade agreements and two comprehensive economic partnership agreements. One is with Japan and one is with South Korea. We call it as SEPA, and this SEPA was executed between India and South Korea in 2010, which is, as I mentioned, is based on the General Agreement of Trade and Tariff. It's a very comprehensive document which not only talks about various products and commodities which gets the preferential treatment or exemptions. It also talks about the socio-economic relationship between the two countries, the balance of trade, and various other aspects which helps two countries to get closer, not just in the trade, but on the geopolitical side as well. A very basic concept under any of these free trade agreements is that the product has to be originated from one particular country. With that country you have an agreement. So if there's an agreement between India and Korea and certain goods are exported from Korea to India, then the Indian importer must justify that those goods are made in Korea, originating from Korea, and then only they can get the benefits which are available under the respective FTA. Currently, as it is mentioned in the slide also, under the SEPA, the Korean side has classified 11,200 different commodities or products, and India has identified 5,200 tariff lines, which are broadly distributed into 6 different categories. where either there is no duty or there is a preferential rate given to those products when the trade happens between India and Korea. So for the purpose of availing such benefit, the most crucial question or the most important aspect is to identify that those goods are made in Korea when those goods are exported from Korea to India. And that is where broadly the dispute revolves around. Can we move to the next slide, please? So once how it works, because it's an international agreement between two countries, so it has to be notified so that the provisions of those agreement can be executed in one particular country. For the same purpose, once the CEPA was signed between India and South Korea, those were notified by the Indian government under the rules of origin through their government body, which is called CBIC, which stands as Central Board of Indirect Taxes and Customs. So they have notified the rules of origin, which are mandatorily to be followed by the exports or imports happening between India and Korea. And those notified rules would prescribe the rules of origin, and they would prescribe the mechanism of certification so that those goods, when imported into India, could avail the benefit of CEPA. So the most important aspect is to define what is the originating goods and what different methods should be followed to satisfy that these are originating goods from Korea, and also the entire process. So two major aspects which deals with the concept of originating goods would be the regional value addition, and other is whether there is any change in the product from category A to category B, which broadly are explained on the next slide. Can we move to next slide, please? So take for an example, again, a television exported from South Korea to India. It may have a value of $100. Now, the most crucial part which is used in the television is your, say, the LED screens. And those screens, say, are exported from China to Korea and are worth rupees or of $65 rather. So out of $100, that value of $65 only pertains to that one particular product, which is not made in Korea, but is made in China. But television as a whole is exported from Korea to India. Now the question comes whether that particular television could be treated as a product made in Korea. Now, in order to settle this issue, particularly for rules of origin between India and Korea, they have identified that if the domestic value addition in a particular product is more than 35%, then that product can be called as a product originated from Korea. So as I mentioned, if under the agreement, if that television is worth $100 and the picture tube is itself is of $65, but still the $35 is absolutely the Korean products and valuation is in Korea, then that particular product can be treated as the Korean product.
됐다. 저것 봐도 돼. 소리만 이걸 들으니까.
아, 그러면
말 안 하고 있잖아, 이제. 아닌가?
May I now proceed?
영어 쓰고 있는 거 맞죠? 근데
알았네요.
영어로 안 들리지?
우리 참석자분들 그 발표는 영어로 진행되고요. 그 마이크는 원활한 진행을 위해 좀 꺼주시기 바랍니다. 감사합니다. Mr. Rupenda, I think you can go on and continue.
Thank you so much.
You're welcome.
So this is one of the basic principle that if you have a regional value addition going up beyond a certain percentage, then that particular product can be called as a local product. So in case of India Korea, the regional or domestic value addition is minimum 35%. And the second major criteria is that a product should change the category under the respective customs tariffs. As India and Korea, they have their respective tariffs. So it should not fall under the same category as it was before the value addition. So Apple should not remain Apple, and it should be mango or something else to be eligible for the concept of value addition and change in tariff heading. So if these two conditions are satisfied and a local authority in Korea, they provide a certificate of origin, then in that case, historically, prior to the introduction of Karotar, these rules, those were accepted and the preferential rate under the respective agreements were given. And that is historically, it used to work everywhere in the same way. Can we move to next slide, please? This is basically the procedure prior to the introduction of the Karotar rules 2020. And when we deal with the rules, we'll see the major shift and what all changes they have made. So if we see the procedure, once an exporter is ready to export his goods to India, the exporter has to approach the designated authority in Korea for issuance of the certificate of origin. And once that certificate of origin is issued, then the original copy is handed over to the Indian importer, who will, while filing the documents for import along with the import consignment, he will hand over that certificate to the Indian custom authorities, who in general, if they agree, they will clear the goods and they will assign the or give the benefit under the respective treaties or agreements. And if they have any doubt, they will write back to the designated authority in Korea to verify and explain if these goods comply with the condition of originating goods and whether that certificate is genuine. In case of positive response, those goods are then thereafter cleared with the benefit. In case there is any doubt or there is any negative response, in those cases, the benefit is denied by the Indian custom authorities. And for all future and subsequent imports also of the similar product from the same exporter, they face the same problem that they will not receive any sort of benefit from the custom authorities in India. So this was the procedure prior to the introduction of the new regulations. Next slide, please. Now, why there was a need to have the administrative rules which were recently introduced was that there were instances that from different countries, people were exporting goods by getting the certificate of origin from their country. But it was found out during the investigation that most of those goods which were exported from country B were not actually manufactured or made in country B, but traded from country A. And they were either fake certificates or there was not up to mark value addition to claim the benefits. And as a result, there was a loss to the Indian exchequers. And also there was a violation of various trade agreements between different countries. One of our such instance in 2019, I have placed in the slide where a product called Erica nut, those were basically procured from a third country and they were declared to be of that particular country. And on investigation, it was found that they don't even have the manufacturing facility to make that product called Erica nut. And still they were trying to get the benefits. So in order to get rid of this difficulty, the Karotar 2020 were introduced. And there was a shift in responsibility from the government to government to the importer. As we could see from the previous slide, whenever there was any doubt with respect to the certificate of country of origin, it was the Indian government or Indian custom authorities who used to write to the designated authority in Korea to verify the claim. Because earlier the importer used to say that I have no idea about the genuineness of the product. I received this certificate from the Korean exporter, so I don't know. I presume that if the Korean exporter has given this certificate, that is supposed to be genuine. So there were no responsibilities casted upon the Indian importer to verify the genuineness, and it was all between the Indian government authorities and the Korean government authorities to communicate and check in case of any doubts. So therefore, to get rid of these difficulties, the Karotar rules and the relevant provisions were introduced. Next slide, please. So prior to the introduction of these rules, there was an amendment made to the Indian Customs Act, and a new provision called Section 28DA was introduced. Now, the relevance of this provision is that it, for the first time, casted a burden on the Indian importer to possess at least a basic information about the product which they are importing. So now they cannot run away with an excuse to say that the certificate was issued by Korea, so I am trusting that. So they themselves have to first make sure that they have a reasonable belief that these products are originating from Korea, and the certificates which are issued are genuinely for the products which are imported. It further gives teeth rather power to the Indian custom authorities to temporarily suspend the country of origin certificates also. Prior to the introduction of this provision, there was no power with the Indian custom authorities to suspend. They can only get it verified from the Korean counterparts. But now, till the time the verification is not completed, the Indian custom authorities now have the power to suspend the certificates, and in the meantime, all imports which are taking place have to be assessed provisionally without the benefit of the respective trade treaties. And they can even deny the benefit if they have a reasonable belief. Next slide, please. Slide 8, yes, thank you. So post introduction of these provisions, the Customs Administration of Rules of Origin under Trade Agreement were introduced. Now, the first basic aim or idea of introducing these rules was that there should be a uniformity, because India has entered into preferential trade agreements or the free trade agreements with various countries, and each agreement has different mechanism and provisions for identifying the originating goods. So there was no uniformity. So in order to create a uniformity in the procedure and administration of these origin of goods, they came up with these regulations, and they again created a responsibility, first-hand responsibility at the hand of importer to satisfy himself and to possess a minimum information, so that if there are any preliminary doubts with the Indian custom authorities, they need not to go to the Korean counterparts or Korean government, but the Indian importer himself can satisfy and cut short the time and increase the efficiency in clearing the goods from the custom port without any difficulties, so that they can streamline the procedure. So this was the objective. Next slide, please. Now, how do we claim a preferential tariff under the new regulations? As we have seen prior to that, the simplest process was to make a claim based on the certificate of country of origin. Now there is a slight change under the new regulations, where the importer has to make a claim while filing the bill of entry, because bill of entry is the document you file at the time of import, providing each and every detail starting from the the particular product imported, its tariff heading, its value, the rate of duty, the name of the exporter, whether there is any exemption benefit available, whether you are claiming that, do you have any certificate for country of origin. So all those details are to be mentioned in the bill of entry. So now they have under the regulation 3 or rule 3, they have created this mechanism where in the bill of entry itself, the Indian importer has to make a claim for preferential rate of tariff, and they have to mention the relevant agreement also. So in this case, they have to mention the agreement between India and South Korea. They have to make a declaration which they will sign to state that the goods which are imported are qualified as originating goods. That means that they themselves are claiming that these are goods made in Korea. Then they have to produce a certificate of origin at the time of filing bill of entry. So that original certificate and under some of the agreements, even the wired copy or emailed copy of that certificate also works. In case of South Korea also, if you have a scanned copy of the certificate, that copy will also help you in clearing the goods. And they have to also indicate the relevant notification which is available to them for getting the preferential rate or the exempted goods. Now, in absence of any of these details or some of these details, the custom officers, they have now power under the regulation that they can deny you the preferential tariff rate. They can, on the face of the document, can say that these certificates are incomplete if the information is not complete. They are invalid if they are expired, or if these are issued for some other product. The Indian custom authorities are now empowered to immediately, without verifying, deny the benefit of the preferential rate and those certificates. Just to assess the audience here, when we talk about the relevant authorities in Korea, so far the Korean Customs Service and Korean Chamber of Commerce and Industry are two different nodal agencies which have been identified under the agreement who can issue this certificate for country of origin for the Korean products. Next slide, please. Now the another shift, as I mentioned earlier also, now there is a burden on the Indian importer that he has to satisfy and justify the Indian custom agencies and authorities before or prior to going back to the authorities, nodal authorities in Korea. So as the rule 4 requires, an importer has to possess sufficient information about the origin of goods, and it has to be submitted in case asked by the custom officials. Very relevant point to note here is that they have to possess. They need not to hand over that information without being asked by the Indian custom authorities. So at the time of import, they only have to provide basic information in the bill of entry. But in case there is any doubt and further questions by the Indian custom authorities, they have to provide a sufficient information, and they are required to have that information available with them, so that at the time of asking certain queries, those informations would be provided. And there is a responsibility or liability under Rule 4 that they have to maintain a record of the sufficient information to be kept safe for a period of 5 years. Because under the Indian customs law, a custom officer, even after clearance of goods under import, they can raise queries in case of doubts in future for a period of 5 years. So that period of 5 years is relevant. You need to keep the records available with you for a period of 5 years. Rule 4 again also provides that the importers should exercise reasonable care to ensure the accuracy and truthfulness of information. When we talk about the reasonable care, it implies that any person with utmost care who deals or who undertakes the business, the kind of accuracy and truthfulness of information he will procure from his counterpart, that is the same thing expected from the Indian importers also. So they should take all reasonable steps. They should ask their exporters that all the relevant information which may be or which might be required by the Indian custom authorities in the future should be kept handy and should be asked for from the Korean exporters. Now, here I would like to point out that this is the situation which can be handled very well from by the lawyers from both the sides. The preparation of information which the Indian custom authorities require from the Indian importers would ultimately come from the Korean exporters. So that information can be provided in a prescribed format with the relevant data and information through an help of a Korean lawyer. And at the same time, when that information is to be handled and tackled with the Indian custom authorities, that's where the Indian lawyers come handy. So one should always consult a lawyer in case there is any issues related to customs, be it in India or in Korea. Now, that availability of sufficient information has not been described very clearly under the regulations, but under the regulation there is a form which is called Form 1, which is provided a basic format and detail has been provided where all the relevant information or sufficient information, what all can be asked for is given. So that is quite handy for the exporters and the importers to know beforehand that this is the sort of information which the Indian custom authorities can ask in future. So one can take a look at the Form 1 and they should keep the information handy. Now, so far, since the burden is given to the Indian importer, any information which the Indian importer gives and the custom authorities are satisfied with the explanation which the Indian importer has given, then they don't go beyond that stage. They don't communicate with the Korean counterpart, nodal agencies, and they don't go there for verification of the certificate. They stop at the same moment if they are satisfied and they clear the goods. And that mandatorily verification of the certificate has been done away with. That is only required in cases when there is any doubt which still remains with the custom authorities. So rule 5 of the rules specifically deals with that situation where either the information given by the Indian importer is not sufficient or that is incomplete, or there are reasonable belief and reasons with the Indian custom authorities that there is a problem or discrepancy in the certificate issued by the authorities. In those cases, prior to communicating with the Korean counterparts, they have a requirement that they should ask for the additional information from the Indian importer, and the information is to be given within a period of 10 days. So there is a timeline prescribed, very strict timeline, so that there should not be any delay in clearance of goods. So within 10 days, the Indian importer has to provide the relevant additional information which has been asked for by the custom authorities. And if even at that stage also, the Indian custom authorities agree that they accept the explanation given by the Indian importer, within 15 days, they have to intimate back to the Indian importer that they have accepted the explanation and they can clear their goods. So within a span of 25 days, the entire exercise has to be carried out so that within a period of, or rather a period of less than 1 month, they can clear their goods without any much delay and without payment of demurrage charges, which ordinarily the importer has to suffer when the goods are lying at the port. So just to match the timelines, 25 days from the date when the information is asked or to the date when the final approval is given by the authorities is the maximum time given under the provision. However, if even the additional information is not sufficient, the Indian authorities have identified a nodal authority in India, and through that nodal authority, they will approach the counterpart in Korea to verify the information and the content of certificate, whether those are genuine and whether those can be accepted. Ordinarily, this procedure is provided in the respective trade agreements also, and there are different timelines in different agreements. But wherever there is no timeline provided in any particular agreement, this regulation, this rule provides for 60 days period to the Korean counterpart or counterpart from the other country to receive the information, verify, and revert back to the Indian custom authorities. So they have to do it within a period of 60 days, wherever there is no time period provided under the respective trade agreements. And in case there is any delay, this regulation empowers the Indian custom authorities that they can even suspend the eligibility of those certificates. So for the pending period, they can certainly go ahead and clear the goods without any benefit. And as and when there is any confirmation given by the Korean counterparts, they can receive their benefits back. And meantime, the goods are cleared provisionally. Now, there's another timeline provided that in case any positive information is provided by the Korean counterparts, Indian custom authorities have to conclude the verification within a period of 45 days, and that a final report has to be handed over. But if there is no information, then there is no benefit. That is a simple, straightforward formula given in the regulation that if you don't provide any information, you will not get any benefit. So that very, very strong onus stays with the Indian importer and in turn on the Korean exporter, because without the assistance of the Korean exporter, Indian importer cannot avail those benefits. Now we'll quickly run through slide number 13, please. It also provides a mechanism for the situation where there are identical goods exported back to back by the same exporter or manufacturer. What will happen to that? Say the first consignment itself, if there is no benefit given under the trade agreement and there is a doubt created by the Indian custom authorities, then even for the subsequent exports also, they will still not agree to give any benefits unless and until there is any change, any additional information provided, or any further documents handed over for the subsequent transactions, where then the custom authorities can consider. Otherwise, the identical goods will get the same treatment unless until there is any change. And same goes with the subsequent assessments also, that unless until there is any change or further development, they will not get any benefit. Next slide, please. The current regulations also provide for a penal action where it is found that the importer has suppressed the facts, or there is any willful misstatement, or they have colluded with the seller with an intention to avail undue benefit for a trade agreement. That could happen in various scenarios. One, the genuineness of the certificate itself. Two, wrong certificate for wrong goods. Three, the classification of goods are not what is mentioned in the certificate, and that has been genuinely not disclosed. So wherever the Indian custom authorities can found out that there is a malafide at the part of the Indian importer, they can certainly penalize, and those penalties are quite heavy, which are imposed on the importers, which may go to certain number of times the value of goods imported. So that is quite detrimental if somebody uses the wrong certificate with an intent to defraud the Indian customs. Next slide, please. Now, as I mentioned, that various agreements have different provisions which may vary from one agreement to other agreement. And there could be certain guidelines which are which in these particular regulations called Karotar may differ or may deviate from the relevant rules of origin in the regulations of respective country. So it provides specifically under Rule 8.3 that if there is any conflict between the Karotar, these regulations, and the rules of origin of that particular country, then those rules will prevail, not these regulations. And just for the reference, in relation to India and South Korea, the relevant rules for origin would be customs tariff, determination of origin of goods under the preferential trade agreement between the governments of Republic of India and Republic of Korea rules 2009. So these, if there's any deviation, these rules will prevail over the current regulations. Next slide, please. These are the basic information to be submitted. We have already discussed that in previous slides. We can quickly run through this, that the importer has to give a declaration in the bill of entry regarding the originating goods. They have to indicate the relevant tariff notification which is available. They have to produce a certificate of country of origin, and they have to enter the relevant details of the country of origin, such as the reference number, date of issuance, originating criteria, etc. And they have to specifically state whether the transportation of goods or the export of goods is directly from Korea or it has routed through some third country. Next slide, please. Now there are, these particular slides talk about the various methods, how one can justify that these goods are originating from Korea. It may, these concepts are, or these can be discussed in detail, and we'll find appropriate occasion to discuss these methods also, but I can quickly run through the basic concepts to make you understand how to justify these are made in Korea goods. So first is the goods wholly obtained. I mean, as the name suggests itself, that if goods are entirely manufactured or made in Korea with Korean raw material, then it is wholly owned, wholly obtained Korean goods, and you can easily get the certificate of origin. If the goods are produced by using raw material which is non-originating material, which is a material which is the Korean exporter has imported from somewhere else, say a Chinese raw material or a Japanese raw material or American raw material, then in that case, it has to undergo a substantial transformation to justify that these are Korean products. And that can be done in three different ways, that either there is a change in tariff classification, or the regional domestic value content, as we discussed in the previous slide, that minimum 35% value content has to be there. You have to justify that. Or as the country of origin rules provide, for certain products, there is a specific processing rule that one particular product has to be manufactured using a particular process. If the manufacturer exporter in Korea has used that particular process, then in that case also you justify that the country of origin of that product is in Korea. We have defined these value content method and change in tariff classification and processing rule method in the same slide. If anybody has any doubt, they may ask during the Q&A. Next slide, please. This is basically a checklist of procedure which one has to follow. You can go through this. This talks about one has to identify whether these are originating goods or not. If these are originating goods, straight away you get the benefit. If these are not wholly owned originating goods, then you have to check whether the general rule will apply or product specific rule will apply, and then whether there is a value content, a change in tariff, or a combination of both, which ultimately concludes that these are goods originating from Korea. Next slide, please. Now, so far we have discussed what all requirements and how it is to be done. However, there is a mechanism provided that if the Indian importer, they don't agree with the decision taken by the custom authorities, where they declare that these are not originating goods. In those cases, there is a mechanism of adjudication provided where, aggrieved by the decision taken by the customs, the importers can file an appeal before the principal commissioner of customs or the commissioner of customs within 60 days of clearance of bill of entry under section 128 and 128A of Customs Act. And as a second leg, there is a second appeal mechanism also provided under section 129A of Customs, that if you are still aggrieved by the decision given by the principal commissioner or the commissioner of customs, you can file your second appeal before the appellate tribunal. And there is a third fast track mechanism also provided, but that requires little extra effort, and one has to show that the order or the direction given by the customs is absolutely perverse. In those certain cases, one can directly approach the jurisdictional high court and prove that the order or direction given by the customs is perverse. And if they are able to convince the court, they can quickly get an order from the High Court where they can specifically direct the custom authorities to get the goods cleared after the benefit to be given under the respective trade agreements. So this is by and large an overview of the regulations and the intricacies attached to the regulations. I have tried to cover in these 35-40 minutes. So we'll be happy to take Q&A later. And now I'll request my colleague, Mr. Jagbir Singh, to proceed with the next presentation. Thank you.
Sorry, in fact, I didn't realize that I was muted. Thank you very much, Rupender, for a very captivating session. And of course, with the permission of Daniel, I will continue. As I had mentioned earlier, he holds the strings. So Daniel, with your permission, should I continue, or you really want to, reflect upon his session? Hello.
Oh, I think Mr. Jaya, I think we can continue.
Okay, sure.
Presentation, and
Sure.
actually we're a little bit running out of time, so
Yeah, sure. I'll try to make it as quick as possible.
we're planning to have like the Q&A session at least at maybe 3:20. So yeah, I'm so
Yes. Yeah. Thank you very much, Ms. Kim. Thank you. Will not take much of your time. Now, we discussed at length, and thank you very much, Rupender. You were very much, very precise, and still, discussed it in details. So what we discussed was how the Korean exporters may face problem at the customs and how those issues can be resolved. Now, I take the discussion slightly further. What if the exports they have been made successfully, and but most of the times, the payments for all those exports, they are not in advance. So there's most of the times they are trade credit basis. So in those cases, we have seen, especially in big supply contracts from Korea as well as Japan, that the Indian counterparts, the purchasers of those materials and services, they sometimes, because of financial difficulties, and most of the times because of general reluctance, willfulness, they did not really make the payments, sometimes at all and sometimes not in time. So we earlier, before the new insolvency code, which was notified in the year 2016, the only mechanism was through filing suits with the relevant judicial courts, and a suit for recovery would take, at the original level itself, around 5-6 years, and then of course you have appellate for example, the High Courts and Supreme Court. So by the time any suit for recovery attained finality, it was almost more than a decade. Then came this insolvency and bankruptcy code. Now, uh, second slide, please. As the basic purpose of insolvency, I will in fact discuss it in very brief, because the focus is not on other aspects of the insolvency and bankruptcy code. We call it IBC. But generally, the basic purposes of this IBC is to resolve the insolvency of an insolvent corporate debtor in India and maximizing its value of assets. So basically, it is to preserve the economic value. This aspect we are not going to discuss much. The second is to recover and to ensure that maximum dues by the creditors are recovered. Now, this second stated objective also, in fact, does not only talk about the operational creditors, that is the suppliers, but also the bankers, financial institutions who gave loan. What we are going to discuss now, it is a prelude to the operations of the IBC, and also we make use of the IBC, the process itself, to recover the dues by avoiding going through the entire process itself, which is time consuming. So next slide, please. Third number. So the Indian law, this IBC, it provides an opportunity for a financial creditor, that is the banks and financial institutions, the operational creditor, which is a supplier. For example, we'll be focusing more on operational creditor here. So the Korean suppliers of goods and services to an Indian company, okay. So to them, and also the corporate applicant, the debtor itself. We are not really focusing on that. So we will be focusing on the operational creditor, that is the suppliers. Now, if there is an outstanding debt of more than 10 million Indian rupees, which in today's exchange basically will be around 140,000 US dollars. If there's an outstanding debt of that amount, the operational creditor can use the tools of the IBC to recover that amount from the Indian purchaser. So but the threshold prescribed for initiation of the insolvency proceeding is 10 million. That is around, as I mentioned, 130 to 140,000 US dollars. This process, is just mentioned that the process of insolvency initiation was suspended because of onset of this pandemic. The Indian industry was really undergoing a very bad phase financially. So the government, mindful of that, they provided a moratorium of 1 year against initiating any fresh insolvency, in cases where the default happened only during this period. So default, if there was already a default before March 25th, 2020, when this pandemic began effectively, the new insolvencies could be initiated even during this period. Okay. Earlier, the threshold was very low. It was only 100,000 Indian rupees, which is almost 1,400 in US dollars. But it was because of the pandemic situation, but also the fact that many unscrupulous small operational creditors, they were trying to keep the large, companies, the purchasers, hostage because of this. Next slide, please. Now, this process, and that is, in fact, of course, we'll be running through this process prescribed under the IBC. but the purpose will be to see all these sub processes as tools to meet our end of recovery of the outstanding dues. So the first process is serving of demand notice. It is a statutory notice. It's not like any other legal notice, say, notice sent by a lawyer, or for that matter, any communication. Uh, you know, it is it is a statutory notice recognized as such under this special statute called IBC. So if there is a default, this demand notice can be sent by the Korean supplier for the outstanding amount to the Indian purchaser, the corporate debtor. Okay. What the foremost requirement for the success of this method is that there should not be any existing dispute. I mean, it shouldn't happen that they have been, the Indian purchaser has already disputed your claim of payment. Then this tool cannot be used, and you cannot initiate or even threat to initiate the insolvency proceedings. So demand notice cannot be sent. But if there is complete absence of dispute, as a dissatisfied supplier of goods and services to the Indian company, you can send this demand notice, and that 10 days period is afforded, only 10 days period is afforded to the Indian supplier, the Indian debtor, to make this payment good. Okay. And if that payment is not made within 10 days, the consequence will be what we're going to discuss in the next slide. Next slide, please. Now, if within 10 days, either the Indian corporate debtor, the purchaser of Korean goods, either it shows that there is an existing dispute, or it makes the payment. No, it also can show that no, we have already made the payment C. Or it shows, it makes the payment itself. And that is the time, this 10 days time, it is the most crucial time. When I say we can use IBC as a tool to recover, that is the time we use. In fact, in our experience, and we'll share with you the ballpark estimate of percentage cases where in many number of cases we have been able to assist our foreign clients in recovery of their dues by sending a very robust demand notice to the Indian debtors, Indian companies, purchasers, and they in almost almost in 1/5 of such cases, I say, probably more, they ended up paying the demanded amount. Because the consequence, otherwise the consequence is this, what we are discussing in this slide. If that payment is not made within 10 days, the dissatisfied Korean supplier can file an application with the adjudicating authority, and this adjudicating authority is National Company Law Tribunal, NCLT. So that is the adjudicating authority. And this application is to initiate the corporate insolvency resolution process. So insolvency, that is the application. Now, why the Indian purchaser, Indian debtor will be very much interested in avoiding the onset of insolvency resolution process. We'll see the consequences of that later. So before that is filed, that is, as I mentioned, that is the time then most of they will come to, knowing the consequences well, they will come to the table, ask for settlement of all the dues, and we have used it very effectively for large foreign clients. Suppose that is not made and the application is filed, then the adjudicating authority has 14 days. But it is prescribed time is 14 days, but sometimes it takes more than that, probably even 30 days sometimes, because notices are issued and Sometimes, there are adjournments as well. So give and take there 1 month. That 1 month time is also because, see, once that application is filed and the Indian debtor gets the notice, he knows the seriousness of the dissatisfied Korean supplier, that he will go all guns after him to recover the due. Okay, so during that period, before the adjudicating authority, as a matter of fact, admits that application and officially starts the insolvency process, uh, in that period also almost equal amount of the Indian debtors, they request the dissatisfied suppliers, in this case the Korean suppliers, to come to the table and settle the dues. And in that case, if they agree, they draw a settlement agreement and file it with the adjudicating authority to withdraw the application already made. So once that is the stage. Now, within, as I mentioned, within 14 days, the adjudicating authority can officially initiate the insolvency process. In the same order, it does actually 2-3 different things. It initiates the process, resolution process. It also appoints an interim resolution professional, we called IRP, and also announces moratorium on several actions against the company, the debtor company in India. Next slide, please. So IRP, see, when this IRP, the insolvency resolution professional, when he is appointed, it also means the management of the then incumbent management of the Indian debtor, Indian purchaser, that is replaced instantly by the resolution professional, the IRP. And that is one thing which the Indian promoters, they fear the most, and that's why they come to the table immediately, either on the issuance of demand notice, which we discussed earlier, or just filing the application with the adjudicating authority, because they then are very much convinced about the seriousness of the, in this case, the Korean supplier. And they also know that if that application is admitted, instantly on that admission, the control of their company, their own company, will be taken away and will be handed over to the IRP. And that is the most important tool which we have been very successfully using all these years. In fact, I think when the day this new code was notified, we had sent the first demand notice that day only, and we were able to recover almost $3 million from a very large Indian company within 2-3 days only. So that was so successful. That has been so successful. Okay, but this is the process. I mean, the procedure, we will not be, for the purpose of this presentation, it is only for completeness purposes. So IRP, the insolvency resolution professional, on his appointment, within 3 days, he invites the claims from all the creditors, both financial creditors, the bank's financial institutions, as well as the operational creditors. Now, operational creditors, of course, in this case, what we are presuming is that this process is being initiated by certain dissatisfied Korean supplier. But this announcement is for the attention of all the creditors of this company, both financial creditors as well as the operational creditors, which may be other suppliers, Korean suppliers, international suppliers, Indian suppliers, and including probably dissatisfied lawyers like us, whose invoices have not been paid. Okay, so within 3 days, that public announcement is made in major Indian newspapers, both English and vernacular. After receiving all these claims, and once they have collated all the claims of financial creditors as well as operational creditors, the IRP constitutes a committee of creditors. Now, see, this committee of creditors, the constituents of this committee of creditors, they are all financial creditors. If there are financial creditors, suppose there are no banks who have lent to this Indian debtor. In that case, banks and financial institutions who have given the loans, they will be they'll be constituting this committee of creditors. If there is no financial creditor, all the operational creditors together they will constitute the committee of creditors, and their voting rights basically will be pari passu in proportion to their outstanding debt against the company. Now, so we have so I mean with each stage the corporate debtor, I mean, of course, he starts knowing and acknowledging the seriousness of the threat, because at this stage he has already been, bereft of his control and management over the company. He has been ousted. So at this stage, it is difficult because committee of creditors, they have already been constituted. The ball is very much in the court of the financial, most of the times the banks and financial institutions now, even though the insolvency process was initiated by a dissatisfied operational creditor, that is the Korean supplier. But having said that, if suppose there's some settlement between the debtor, I mean, in this case, the settlement with debtor actually is not that relevant. Here, if some of these financial creditors, because it has been initiated by the supplier, Korean supplier, which is an operational creditor, there is a possibility that some of these the financial creditors, the banks, they may not actually want this process to continue. In that case, they may decide amongst themselves by 90% voting by value, and they may actually put a stop to the insolvency process by seeking approval from the adjudicating authority. But that can be done only till the time expression of interest from the potential bidders, who are going to bid for acquisition, which we are going to discuss later. Before that expression of interest is invited. Before that, only they will do, because once the expression of interest is invited, even the this committee of creditors cannot, as a matter of fact, withdraw or put a stop to the insolvency process. Next slide, please. 7 number. Now, this is something which I was talking about, and that is on the basis of our experience. As I mentioned, we have, assisted our clients, mainly the foreign clients, in recovery of their legitimate dues from Indian debtors, Indian purchasers. And these are the different stages and their respective percentages. But that is only on the basis of our experience in last 5-6 years rather. Almost 30 to 40% of all the settlements, they occur only on issuance of the demand notice before that application with the adjudicating authority is filed. So it is, and that is the success rate. You can see, in fact, almost 40% cases of all the settled cases, we end up drawing the delinquent Indian debtor, Indian purchaser, to the negotiation table, and most of the times there are settlements with very little haircuts, very very little haircuts. Most of these settlements, they are in the shape of just prolonging the payment period. They can be dragged, and but most of the times we have seen very good quality of recovery because of threat of initiation. Equal amount, almost 30 to 40, in fact I'll say 40% of settlements, they occur after the uh, after the filing of application with the adjudicating authority, but before it is formally admitted and the insolvency resolution process is initiated. Because it is see there are two types of delinquencies we need to understand. One is where the Indian debtors, they have the capability, financial capability to pay off, but they are willful defaulters. That is and most of them actually try to negotiate in the first go itself when the demand notice is issued to them. The second category is where they may have some financial capability, financial problem, but not to the extent that that problem renders them completely incapable of paying. So these are the people who will come to the drawing room to discuss when you have shown the earnestness by filing your application with the adjudicating authority. So these 40% people. They say, okay, I mean, we are in financial distress, but I mean, we are not really, in the situation where we can actually danger the cessation of our control over the company. So we will try to use our wherewithal, garner all the resources, whether we have to take loans from other people, etc. But we'll try to pay you off. So these are the people. Now, where the financial capability is minimal and almost absent, these are the cases where they said, okay, in any case, we are not in effective control of the company which we nurtured and probably created as well. So let it be, let it go to the next stage, and the insolvency be started. But at that stage, it is very rare. It is only at the will of the corporate, the committee of creditors, as I mentioned. But we have seen some cases where the insolvency resolution process was halted and actually stopped at that stage as well, by the blessing of 90% of the committee of the creditors in that committee. And in most of those cases as well, the legitimate demands of the operational creditors, they are met to the extent possible. But the negotiating power which an operational creditor could have used in the first two stages, that is almost absent here. Next, please. Now, see, it is, we discussed in the first thing, it was very much in continuation with the Rupender's presentation, that the exporters, they are able to export, but they are dissatisfied because of non-payment of their dues, and how we can recover their dues. That is one opportunity offered by the new insolvency code. The other opportunity which is available to the Korean industry is the potential acquisition of distressed assets, but very valuable assets, actually, as a matter of fact, in India. Sometimes what happens is that the distress is more economic rather than financial. Probably some of the companies, they might have been under mismanagement, even though they really boast of wonderful assets, and we'll give you examples later. So once this is admitted, and it is, so it's the way we have structured this presentation is also keep pace with the continuation of the process. So once when the COC was constituted, now in after the COC is constituted, then the process of creating the background and material to invite the interest of potential acquirers, that is done. So all the information by the resolution professional, all the information is gathered and collated in the form of an information memorandum, submitted to the committee of creditors, get its blessing. And they may also, the COC also may, offer their views about the content of this information memorandum and may ask for changes. On the basis of that, the resolution professional, again, through a public notice, invites the interest from the potential acquirers. We in legal lingo we call it a corporate applicant, resolution applicant. But I mean, for our general parlance understanding, I will refer to them as the potential bidders. So more particularly the potential Korean bidders. So this is the process. I'm not going to go deep into how many days, etc. Generally, so the bids are invited. Bids are invited by the resolution professional by way of public notices in Indian newspapers. That the document which invites the expression of interest, contains all the eligibility criteria, the disqualifications, of course, data room access as well for due diligence, the timeline and manner of submission of the bids. We call them resolution plan, and also conditions, subsequent and definitive agreements. Basically, the formats as well. Sometimes they end up offering. So upon that, the resolution professional receives expressions of interest from the potential bidders, just have a review of them and prepares a provisional list of the eligible bidders on the basis of the eligibility criteria and disqualifications, parameters mentioned in the information memorandum. So next slide, please. 9 number. So this information memorandum, along with evaluation metrics, how this, the target, the insolvent company, the target, it is being evaluated, and then from the shortlisted, bidders, the resolution professional will ask for their bids. In fact, their proposals, we call resolution plans. Basically, the bids. In fact, it is a very comprehensive document, and the contours and contents of these we will be discussing in the following slide, I think. So this, after the resolution professional has asked for the resolution plans, that is the bids, bid documents. The minimum of 30 days is given to prepare that. But generally, it can be as long as, say, 80 to 90 days, sometimes more as well. Some extensions are provided, depending upon the intricacy of the process itself, the intricacies involved in the, the nature of the corporate data. Next, please. 10 number. Now, so on the basis of that, the resolution professional, draws the final list of the bidders, and because whatever the bids, the resolution plans, which were filed by the bidders, they are scrutinized by the COC, the Committee of Creditors, and Committee of Creditors then shortlist the final bidders. Basically, so out of say 10 bidders, these 3 4 they are in the final list because they match the requirements of the Committee of Creditors generally, and also the legal requirements under the code IBC. As I mentioned, these are the contents and contour of our resolution plan. It is a requirement of law under the IBC to give priority in payment to the operational creditors, but there is a catch. They get the payment in proportion to their dues, but on the basis of the liquidation value of the corporate debtor on that date. So if the liquidation value probably sometime many a times it is in negative, legally the operational creditors may not really get anything. But the courts, they have been slightly sympathetic towards them, and every now and then there have been judgments where the courts, they exhort the Committee of Creditors and resolution professional to provide for some level of fairness, even though legally they might not be entitled to any amount in a particular situation. But having said that, there's a priority in payment to the operational creditors to the extent they are eligible to get on the basis of liquidation value. Also, this bid document, the resolution plan, it contains a very detailed statement on how this company is going to be run. Your business plans and your further investments and your thoughts about keeping it as a not only keeping it as a going concern, but also keeping it out of this financial stress they are in. And also generally how they're going to take care of all the stakeholders, especially the creators, financial and operational creators. And this resolution plan is to be blessed by the Committee of Creators. Therefore, it is a kind of settlement between the bidder and the Committee of Creators. Generally, we'll see in subsequent slides that it is a win-win situation. The Committee of Creditors, they agree to a hefty haircut, and that is also a win situation for the potential bidder, because after that haircut they actually end up getting wonderful, potentially really viable assets at a very big discounted price. Next, please, 11 number.
Oh, Mr. Jaibar, sorry to interrupt in the middle, but I think we're a little bit running out of time, so
Yeah, we'll quickly. I'm really sorry. In fact,
no
Upender
worries.
took much of time. I will try to do it as soon as possible. Sorry.
Okay, thank you.
Yeah. So in a nutshell, see, so the process I will not really pay much attention to. So these you can read yourself. I mean, so basically that bid is provided, and so next slide, please, 12 number. These are the entities which are not eligible. We are not going deep into that because they are mostly related to the corporate debtor. So the Koreans are not going to be affected unless they are the shareholders there. So let me focus on slide number 13. Now, why these are great opportunities and what are the challenges? As I mentioned, they are really lucrative asset. Bhushan Steel was acquired by Tata Steel. The total debt was around $8 billion, and they got it in $5 billion, and with a haircut of $3 billion. And it's a wonderful asset, and they have been working very well, in fact, functioning very well. Different sectors we'll see, so that they can be of Korean interest. It's a time-bound process. That is a challenge, but we can really meet that challenge by really doing it in a very organized fashion, which we'll discuss later. Way forward is, I think, at the company level, Korean company level, you can have empowered India growth related group, which can keep pace with all these developments. And in fact, we can share the information with ICCK as and when the opportunities arise. And the relevant players in different sectors, they can, in that case, take internal decisions to just opt for this process efficiently. Next, please, 14 number. It is only 3-4 more slides, so another 3-4 minutes only, please. So, these, as I mentioned, Jupiter Law Partners, we can provide you timely information as soon as any new insolvencies initiated upon the admission by the adjudicating authority. We will get that list. In fact, I will ask our team to visit, and we can actually shortlist from that certain interested targets, and the basic information we can share with ICCK. For example, suppose there's some in steel manufacturing, and with the latest annual report, we can share with ICCK, and the same can be disseminated by ICCK with all the members, so that they can have their initial discussion, internal discussion themselves. Okay. The members, upon receiving, suppose there's some player in metal manufacturing, copper manufacturing in Korea, and the target is in the same sector. On the basis of that annual report, they can internally conduct the basic background check. We can also help, or you can really use other consultants or lawyers in India to conduct that background check and due diligence, so that they can prepare and they can really have more resolute decision going ahead when the expression of interest are invited. These are some of the these are some of the data. These are the sectors where most of the time, mostly these targets they have been available: food, beverages, chemicals and chemical products, electrical machinery, and you can just read them. Will not take much of your time. Real estate is in fact a very difficult sector. I will not really advise the foreign players venturing into it in the distressed asset. But most of the other sectors, especially the manufacturing sectors, they offer wonderful opportunities. These are, in terms of the initiation by the operational creators, the suppliers, financial creators, the bankers, and the debtors themselves. Is till October, in fact, December 2021. Number 17, please. Status as on today in December 2021. The total number of insolvency initiated was around 5,000. And you'll see, they were closed, either settled 714, or they were withdrawn 562. So around 1,200 out of 5,000, they were settled or withdrawn. And most of the times, these are the cases where they have been used as good tool by the creators, including the suppliers, to recover their amounts. So you can see, you can gauge the success percentage of success, even in those cases which they were initiated. So these are the stray facts. Basically, these are the name. This is the slide number 18. These are the major cases. You'll see, the recovery by the financial creditors is generally to the tune of 42 to 44%, operational and financial creditors. And it also means that there's a haircut of more than 50%. So the operational and financial creditors, they get their money back to this extent, which they could not have got otherwise, but for this process. And the acquirers, potential acquirers, they get a great haircut to the extent of more than 50%. And after good due diligence, in fact, this offers a great opportunity to them. Thank you very much for bearing with me, and also with Rupender, and happy to answer all your questions.
Thank you very much, Jagbir Singh and Mr. Rupender and Mr. Danieli. Thanks a lot. and it has been really giving a lots of good insight, and also in the basically indirect taxes, custom and indirect taxes, as well as in the solvency part of it. So let's have quickly 2 or 3 questions, because we have already run out of time and people are trying to come out of it. Anyway, all the people, if the questions are not answered, you please mail it to ICCK, and through our esteemed speakers today from the Jupiter Law Firm, we will get all the details back to you.
Sure.
So that much we owe it to you. So you can ask, maybe we can have 3 questions, and then rest of it we will answer through email. Miss Hoyon, maybe you can ask a participant to ask question in Korean.
혹시 이거 발표 이제 강연은 다 끝났고요. 혹시 질문 있으신 분들은 마이크 켜시고 자유롭게 질문해 주시면 됩니다. 혹시 질문이 있으신가요? I think we can wrap it up now because it seems like, yeah, there's no questions. So
I think because it's we do not know.
Yeah,
Are
there
there
is
any
one.
question? Are there any question in the chat?
in the chat, when I checked the chat,
No, there is one question now from Jeon Sung-bi.
Okay.
There's a question. So how about CPTPP? If India joined the CPTPP, the origin the term could be different. There is
Rupinder,
one.
for you.
It might, because right now they are still doing the deliberation, and they have basically not agreed to that comprehensive and progressive agreement. But if they do, then there may be a uniformity with respect to more than one country, various countries all together, and they may have specific rules of origin regarding it. But take my words that it will not be much different from what we have today. They will have to follow the same sort of principle, because by and large, globally, that is what they follow.
Any more questions?
Hi, one more question. Do you hear me?
Yes,
Yes.
yes, please.
Yeah, sure. One more question for Jacques Bill.
Yes.
So for the insolvency proceeding, CIIP process to be initiated, we do understand that there cannot be a pre-existing dispute.
Yes.
So how would you define a pre-existing dispute if there has been a short email from the Indian supplier disputing the demand? Will that constitute an existing dispute?
Yes. Actually, this is one issue which has been treated by the adjudicating authority and the courts as well. Pre-existing dispute does not have to be at some judicial forum. It can be in the form of any documented evidence that the corporate debtor, the Indian debtor, was not agreeing to the claim. It can be in the form of an email, as you mentioned, but all these disputes, they have to predate the issuance of demand notice. So it can be, and the other example is, for example, if uh, there's a meeting between the corporate debtor and the creditor, operational creditor, and the minutes of meeting, they are well documented and signed by both the parties. That is another evidence. So basically, whatever irrefutable evidence is there to show that the Indian debtor had actually disputed the genuineness or quantity or probably nature of the demand, the claim, that can be said to be a dispute.
All right. Thank you.
Yeah, welcome.
Thank you very much, Mr. Jagbir Singh and Mr. Rupendra Sinmar, Danieli. Thank you very much, and thank you all the participants for joining in large numbers. Please share your questions with ICCK, and we will get you the answer through our partners, Mr. Jagbir Singh and Jupiter Law Firm. And let's keep in touch and build the business for Korean firm and the Indian firms. Thank you very much once again for joining. And thank you, Mr. Danieli, for a very good coordination in the beginning and starting of the event, giving a very sound brief for our speakers. Thank you very much. Thanks a lot.
Thank you very much, Mr. Sinha. It's a
Thank
great
you.
pleasure to meet you today,
Yeah.
and congratulations, actually, on taking this office. We do visit Seoul every now and then. In fact, before COVID, we used to visit at least twice in a
Yes,
year. So if we are there, we'll definitely give you a shout.
yes, yes.
Yeah,
We will have a chance to meet. Yes,
definitely. And thank you very much. Thank
thank you.
you, Miss Kim, Daniel,
you.
and
Thank you
to all
so
the
much.
participants. It has been a great pleasure. Really
Thank
enjoyed
you.
it. Thank you very much.
Thank you.
Thanks very
Thanks a
much.
lot. Bye.
Bye bye.
Bye.
네, 오늘 참석해 주셔서 감사합니다. 발표 자료는 여기 써주신 이메일로 저희가 보내드릴게요.
감사합니다.
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 Thank you, everyone. Bye.
Bye.